IHL Talks are a series of events on international humanitarian law and current humanitarian topics, taking place usually 6 to 7 times per year. And it's the occasion for academic experts, practitioners, policymakers, and journalists to discuss burning humanitarian issues and their regulation under international law. Today, the IHL Talk is aimed at focusing on substantial and procedural challenges to the effective and principled promotion of the international humanitarian law and jus ad bellum within the United Nations Security Council. It's also an occasion for the Academy to officially launch and discuss the findings of our briefing paper number 17. This briefing paper has been researched and written by our researcher, Emily Max, who will be part also of the panelists today. The Geneva Academy focuses its research activities on 4 main clusters: digitalization and new technologies, non-state actors, sustainable development, and implementation and accountability. The briefing paper presented today and this event illustrates the available expertise at the Academy and the type of research that we are conducting, in particular under the research cluster on implementation and accountability. Our research in this domain aims at accompanying existing mechanisms and their stakeholders, ongoing policy discussions, negotiations, reforms, new developments, in order to ensure the ongoing relevance of international legal framework for the most vulnerable, along with accountability and redress for the victims. The Geneva Academy has a long experience on the analysis and research about the UN system and treaty bodies. It was a great interest to focus these times on the UN Security Council and IHL. First, because the academic literature is not as developed as it can be for other topics, and also because of the increasing involvement of the UN Security Council with regard to IHL. Following this first analysis, it should be of great interest to also analyze the involvement of other UN system bodies with regard to IHL, such as the General Assembly or the Human Rights Council. But these further interests are in musique d'avenir. So let's focus today first on the UN Security Council and its practice towards IHL. So I let you now with our moderator, Mr. Chris Harland, who is a Deputy Permanent Observer and Legal Advisor to the ICRC delegation to the United Nations in New York, and our panelists. Unfortunately, I will not be able to stay the whole event, so I wish you to spend a fruitful time with our panelists. Thank you, and yeah, Mr. Harland, the floor is yours.
Thank you very much, Maud. And let me just say at the outset, what a pleasure it is to be with you here today to moderate this discussion on promoting international law while at the United Nations Security Council. The title, as you've seen, is a Sisyphean task. And I guess that's part of the question that we're going to be asking ourselves here. If it really is the work of Sisyphus, is there any chance to at least move the ball a little bit further up the hill? Or are you, let's say, destined to remain at the same level constantly? So I think that's part of the questions and what we'll be exploring a little bit here today. There are, of course, many areas of international law that can be discussed at the Security Council. Of course, dealing with international peace and security is the mandate of the Security Council. And so it would be an enormous task to try to cover it all. And so we've decided to look a little bit more carefully at a few different issues, concentrating a bit on IHL, a bit on ad bellum, what can be done in the humanitarian sphere. And so we'll look at that in some detail. We're very lucky to have three excellent panelists with us today. And we'll start with Emily Max, researcher at the Geneva Academy, to give us a little bit of an idea to frame it based on the Room for Maneuver, the Briefing 17 report that she did on promoting IHL and accountability while at the Security Council, looking a little bit at the role of elected members. After that, we'll hear from the legal advisor of Mexico at the Security Council, of course, an elected member. And then we're very lucky also to have with us Naz Modirzadeh from Harvard's PLAC program, who will provide us a little bit more information on one particular issue relating to counterterrorism and IHL. So let's begin. Let's start with Emily to give us a little bit of a framing and what are the challenges, what are the big issues associated with IHL and international law at the Security Council these days. Over to you, Emily.
Thank you so much, Chris. Good afternoon, good morning to those of you who are in the US. First of all, I'd like to thank you, Chris, you, Naz, and you, Pablo, for agreeing to participate in the event. I'm very honored and excited to share the floor with you today. And as explained by Chris, my remarks are based on research published by the Geneva Academy, namely our briefing number 17, which is accessible online. And as the briefing does, my remarks will also focus on the role and work of the so-called E10 members of the Security Council. So for those of you not too familiar with the Council and the jargon associated, E10 are the non-permanent elected members, geographically diverse, that are elected to the Council for a tenure of 2 years. So for instance, Mexico just started its work. And before getting into specific example of work that they've achieved in past years, I want to explain a little bit of the dynamics associated with being an E10. So of course, being elected for 2 years and working alongside the 5 permanent members that are always serving on the council comes with a set of challenges in terms of the workload that increases significantly from being a member to a member of the Security Council, but also financial and human resources, because obviously with the workload, you need to increase the number of people working at permanent missions, and just the size of permanent missions in New York vary greatly from the P5 to smaller countries with also less financial resources. And this, I think, impacts also the amount of things you can achieve or hope to achieve while being on the council. And another challenge that comes with being an elected member is the fact that the pen holdership for resolutions and other outcomes of the council is usually reserved to the P5. So pen holdership means the control of negotiations, but also the authority of calling meetings, of organizing field trips. So being a pen holder or one of the associated pen holders on the resolution really involves being able to control the amount of substance you put into the word discussions and reflection of the council. And it's something that is usually being controlled or kept by the P5 for obvious reasons. Despite this relatively bleak picture, I think it's important to underline the opportunities that elected members nonetheless have in their work. The first one is that they do have a collective veto power over the adoption of Security Council outcomes, because those need to be adopted by a majority of the council members, and the majority of 15 is 8 and not 5. So if the if the E10 are sufficiently coordinated and organized and work well together, they actually can leverage this collective veto power to insert language or refuse language or other items in resolution outcomes. Obviously, there is also room for maneuvers and opportunities for the E10 that come from the increased polarization and the increased disagreement within the group of the P5. that have been attributed to the situations in Libya and the authorization of the use of force in the Libyan context in the early 2010s, and more recently Syria. So the I10 have been allowed, or have been able, to use these divisions to their advantage and act as bridge builders between the P5. So in conclusion, a strong elected membership, so a strong group of I10 has been in recent years, since 2013, which is where the research goes back to, more creative in approaching existing issues and also proposing outcomes and areas of work on the council. And those examples interestingly relate a lot with regards to international humanitarian law, and that's what I'll focus on now. I'll talk about two examples of items where the work of the I10 has been incremental in actually pushing the rock a little bit upper the hill, like Sisyphus, as Chris mentioned. So let me start by explaining that IHL is not a specific item on the council agenda. It's not in the program of work per se, but you can see IHL issue through the prism of either geographical items or thematic items. And for today's discussions, I'll focus on one of each. The first one is a geographical item, and it's the one on the Syrian Arab Republic. And I want to talk specifically about the resolution on cross-border humanitarian access. It's an interesting example because it's, first of all, Syria is emblematic of council, very political dynamics with the involvement of Russia, of course, but also of other P5 in the context, but also because the resolution is one where exceptionally members of the I10 have managed to become pen holders, which is very, very rare, if not unique with regards to geographical items on the council agenda. And what I want to say about this resolution specifically is the following. It's been a real achievement of the I10 to secure in early 2014 a resolution, which is resolution 2165, that authorizes cross-border humanitarian access to Syria through 4 points of passage from Jordan and Turkey. It's an incredible achievement because first, as I said, securing pen holdership wasn't a given and it wasn't usual in the council work. But it's also a noteworthy achievement because the resolution is really the result of the concerned I10, which at the time were Australia, Jordan, and Luxembourg, working strategically and very, very incrementally towards achieving a goal that served a humanitarian operational purpose on the ground. And the resolution was adopted in 2014, but the work really started in 2013. First with the negotiation and the adoption of a presidential statement on the issue, but then also with the adoption of a first resolution, which was resolution 2139. So it took all those months and all those steps and all those negotiations with the P5, with the rest of the council to secure cross-border humanitarian access, which wasn't even mentioned in the wording of the previous instruments. So I think it really shows that it's about patience, it's about staying focused on one goal, and it's about working together with other I10, but also making significant compromises. So for instance, a lot of compromises were made on issues of criminal accountability, ICC referral, but also the reference to Article 41 of the UN Charters. So from a humanitarian perspective, Resolution 2165 was a big achievement, but from the perspective of IHL or maybe criminal accountability, it was a little bit more mixed results. And the resolution has served as a basis for the renewal of access since 2014, with I10 changing in being the pen holders as some were leaving the council and others were coming in. And renewing the authorization was relatively straightforward, but became increasingly difficult since 2018, with China and Russia putting forward increasingly different narratives with regards to the conflict, so arguing that cross-border access was not necessarily anymore because the regime was regaining grounds and that you could go through Damascus to fulfill humanitarian needs. And so the E10 have had to do increasing work and face increasing difficulties and demands from Russia and China and others in terms of language. And the latest text that we have has gone from 4 point of crossings to just 1. And so while you could, see the glass half full and say E10 have managed to keep pen holdership in an increasingly polarized and politicized environment, and they're still fulfilling needs on the ground, you could also ask yourself the following question, which is, at what point do compromises that you have to make on substance and on needs, so the closing of certain checkpoints, increasingly control mechanisms of what kind of aid can go in or not, is considered as an achievement, or at what time actually saying, you know what, we cannot get this passed in a way that is principled and the way that we actually would like to, and blaming, the states responsible for it would be more appropriate. So where do you put a red line, and at what time does the promotion of humanitarian goal is not being fulfilled if you have political gain? And I think the Syrian context is very illustrative of those questions, but also you could have similar questions with regards to the thematic agenda item on protection of civilians, which is where I'll turn to next. So it's an agenda item that is 20-year-old, and there's been a lot of discussion and questions already about where the item started and how it has transformed. But for our purposes today and the research purpose, what has been noteworthy is that since 2016, there has been 4 thematic resolutions on specific IHL issues that have been adopted under the umbrella of this item, namely Resolution 2286 on healthcare in armed conflict, Resolution 2147 on hunger in armed conflict, Resolution 2474 on missing persons, and Resolution 2475, if I'm not mistaken, on person with disabilities. And the commonalities between those resolutions that I want to highlight today are the following. So each of them is the result of the initiative of an elected member or of a geographically diverse group of elected members, following very, again, incremental and strategic steps, like was the case for the Syria resolution. These resolutions concern issues that states have either been working on for a long time, as was the case with the Netherlands and the resolution on hunger, or issues that states were directly concerned with, like was the case of Kuwait with missing persons. The adoption of the resolution often coincided with the concerned states, or one of them having the presidency of the council. So really being a sort of little prize that, states could show at the end of their presidency. And the texts were often elaborated in close consultation with humanitarian agencies like the ICRC or OCHA, for instance, but also concerned NGOs like MSF, for instance. So on the one hand, you have the Security Council suddenly grasping issues of IHL that are relevant from an operational standpoint, but that are also, if you look at it a little bit more negatively, not too political, so also relatively easy to grasp. But on the others, it raises questions with regards to, is it really the purpose of the POC agenda item to address rules of international law? Doesn't it contribute to the fragmentation of the item? And then on a systemic level, I think the question can also be framed in the following terms. If you don't have specific mechanisms for compliance, as is one of the big challenges with IHL, and if the resolution on those issues don't have language addressing consequences for violation, either through criminal ways, international criminal ways, or sanctions, is the purpose of the resolution to merely reaffirm the political relevance of rule that already bind states through treaties or customary law? Or does it contribute to making IHL a more robust legal framework. So because IHL is a body of law that exists and was formed outside of the United Nations, what is the normative and operative added value of having Security Council resolution on those issues? And I'm fully aware, and were most of my interlocutors doing the research, that those are very hard questions that have no easy answer. But I think if you're in the shoes of an elected member to the Security Council, working with those states as an NGO or as a humanitarian organization or in academia, it's your role and our role today to ask those tough questions. And in concluding, I want to ask several more tough questions to leave you with, and I'd be curious to hear Naz's and Pablo's views on them. So, if you're an E10 on the council, how do you measure failure and success if one of your goals is actually to promote IHL? Is success the preservation of the integrity of the legal framework, or is it political gain or political momentum that you can show to your constituency at home or to other states on the international arena? And if political gain and the preservation of the legal framework cannot equate, and if you cannot achieve the two together, to which do you give the precedence and at what cost? So how do you draw red lines with regards to the preservation of the legal framework? So how do you, in other words, and to come back to Chris's framing of today's discussion, make sure that the ball, Sisyphus ball or rock, goes up or at least stagnates and doesn't go down on your watch? Thank you so much, and I look forward to the rest of the discussion.
Thank you very much, Emily, for that overview. You've touched on areas that are of real importance for the ICRC, certainly, and I think for a lot of the legal advisors working in missions here in New York, and those who are interested in the work of the Security Council in relation to international law generally, IHL in particular. Of course, the cross-border resolutions, very challenging. It's sort of really the height of politics meets international law more generally, including issues around state sovereignty, which make it, of course, even more challenging in a divided council politically. The four resolutions that you mentioned on healthcare, hunger, disabilities, and missing persons are ones that, of course, we were very interested in and happy to play a role in. And then finally, I think you asked an excellent question, which is, if you've got law already, are you worried about having the Security Council, with all of the politics associated with it, touch that area of the law for better or for worse? The better is you get language that you can use many places, and maybe you even improve sometimes on existing language in IHL treaty and custom. But then at times, of course, you worry about what wording you might get out of it. So that's certainly a question that I think is being asked quite a bit here in New York. Thank you very much for the presentation. A reminder again, if you've got questions on that, please ask them in the chat. We'll collect them, and then after the three presentations, we'll start to get into some of the questions you asked. So again, thanks very much, Emily. We'll now turn over to Pablo Arrocha Buenaga, who is the legal advisor of Mexico here, and someone with whom we've had the pleasure of dealing with. He's a bit of a doyen of the legal advisor community here in New York, and he's always interesting, always someone in meetings that I look forward to hearing. I think it hasn't been many events that I've been to, Pablo, where I haven't heard you speak. So I really look forward to you giving us a lot of your thinking on this issue, which I know is of big importance to your delegation and to you and to your ministry. And I understand that you're going to be talking a little bit about Article 51, a little bit about use ad bellum related issues, and some of the work that you've been doing on in a number of areas, consent and otherwise, relating to the work of the Security Council. So Pablo, over to you. Thank you.
On the contrary, thank you, Chris, and thank you very much to Geneva Academy for inviting me and for organizing this panel, which I think it's very useful and already very interesting. and I'll try to offer as much information as I can on some of these issues in the little time that we have, and I also look forward to the conversation and the discussion that we might have later. And so, Chris, you were framing it in the correct way, I think, which is that my intention is to talk a little bit about, not only as an incoming elected member to the council, but in general as a very active member in the work of the UN or as a whole, on how do we see and follow closely the issues that have to do with the development of international law in both organs. And I think there was one comment that you made at the very end in the wrap up to Emily's presentation that is a very good link to what I would like to talk about today, which was this question of, well, if you already have the law and the law is already in place, then how much do you want the Security Council to continue developing these things or not? And that is a very interesting question for the topic I'm going to address, because I believe that part of the issue is one of two options. Either sometimes you don't necessarily have the law, which in the city context has been a key component, especially in the development of rules that the Security Council has made through decisions. But also, what if you have the law, but it's not an issue of creating or legislating international law, but of interpretation and application of international law, and where viewpoints vary greatly. And this is where this issue on Article 51 comes up. And just saying the issue on Article 51 sounds very cryptic, so I'm going to spell it out now more clearly, especially for all colleagues listening to us. And by the way, I'm very happy to be joined in this with Naz, because she is in reality the origin of this whole story, at least for the Mexican delegation. And so what I will do is first tell you a little bit of how this came to be an issue, at least for us. What is the issue in itself? What's the problem, the legal problem that we see? What's Mexico's proposal on how to tackle it, and what is our view on a way forward, both in the Security Council as well as in the General Assembly, where, as we always say, we are permanent members. So that's something that we also care about deeply. So Article 51 issue. A long time ago, when hugging and kissing people was not a social taboo, and when we were still happy to see other human beings, there was this practice of a group of delegations and legal advisors. There were 4 delegations that organized a series of brown bag lunches, informal lunches in their missions, where they would invite Naz as the head of the Program of International Law and Armed Conflict of Harvard, so that she could give us a very brief presentation on a topic that would be relevant for legal advisors, very informal, Chatham House rules. It was more academic than anything else, so that at least we legal advisors could be kept up to date with many of these issues. And I was relatively new as a legal advisor. I'm thinking this might have happened somewhere between 2016, 2017. And also I'm putting reference to the year so that you can see that sometimes you get tired being Sisyphus and just holding that rock for a long period of time. And we had a lunch where I went there, and Naz was talking about the interpretations that states had been given to Article 51 in the context of fighting against non-state actors, in particular terrorists, and specifically framed in the context of the war and the conflict in Syria. And when she was explaining this, and when she was showing us some of the letters that member states had submitted to the Security Council based on Article 51 to invoke self-defense in order to take military action against terrorists in Syria, she mentioned that on the view of some states, this interpretation of a state being able to intervene in a third country when that country was, and I'm quoting, unable or unwilling to face these challenges, was becoming a trend, and that some were stating that it might even be becoming evidence of a new interpretation of customary international law in the way in which we would now read Article 51. And so when I heard that, which by the way was the first time I was hearing that in general, like that had not been in our radar so far, I almost had a stroke. I said that that it was fine that the lunches were informal and that it was Chatham House rules, but I wanted to be on the record that Mexico holds that view and that we did not support the idea that that was a rule of customary international law. And that was a trigger. That triggered us to really delve into these issues and to take a deep dive to analyze what was the problem. And so the problem, which is the second point of the presentation, and then of course, Nas and I conversed many, many times separately. The problem was this. So since 2014, and in accordance with Article 51, which as we all know, talks about individual or collective self-defense, more than a dozen states had informed the Security Council of military action taken on the basis of that article to combat non-state actors, specifically terrorist groups, without the consent of the state in which the operations were executed. Again, as I said, most of these situations related to the fight against ISIL in Syria. The language used in these communications was not uniform. Some states, when they submitted their letters, they used the reference of the Syrian government being unwilling and unable to prevent terrorist attacks. Others avoided expressing that reference, but made a similar analysis saying that the Syrian authorities did not exercise effective control within their territories. And so we started also from the Mexican point of view, making a thorough analysis of what Article 51 said. And we, like, the first thing that immediately comes to mind is that there's nothing in Article 51 that talks about a willing or unable standard, or to a standard of exercise of effective control. What you have is the trigger of the inherent right of individual or collective self-defense if an armed attack occurs. And it doesn't even talk about non-state actors, which is also a different conversation. However, we were concerned about this notion of why or how could people just assume that there's a customary interpretation being emerging if there's a handful of countries, a little over 12, 13 at the time, maybe 14, that have in one way or another made this reference. And the key element for that was that there was this perception or this notion of silence, that if the large majority of UN member states were silent about these issues, then in a way that meant acquiescence. And we started to contest that idea. And basically, we also started to explain everywhere we can, and we continue to do so, that the silence of the majority of member states is not a reflection of an opinion juris of acquiescence and of an acceptance, but in reality is the result of the lack of transparency and publicity and accountability of the Security Council. And the reason why I say this is because all of these letters that states submit to the Security Council are public, they're not confidential. However, in practical terms, it's basically impossible to get a hold of them unless you have a contact or a colleague that can give them to you. These documents are circulated only to Security Council members, not to the broad membership. And if you are, Mexico was at the time just a member of the General Assembly, and you don't get these documents because they're not distributed, and you want to get them, first of all, it's like what comes first, the chicken or the egg? Because how can you look for something that you don't know is out there or has been submitted? But even if you knew something had been submitted, if you want to look for it within the UN system, for the official document system of the United Nations, it will ask you for some of the information that is contained in the letter, including maybe the symbol or the date or titles, things that you don't have, so you cannot search for that. The repertoire of practice of the Security Council, which is the repository for all this information, also is published with a little bit of a delay. So we don't necessarily can have a recourse to that as an immediate source to get the letters. And as a delegate, if you subscribe, which by the way, it's a system open for anyone. If you go to the Security Council webpage and subscribe to the e-subscription, to the UN documents system, You will receive a daily email with all the documents that were published that day of the Security Council, but it's just a list of symbols. So you would still have to click on each one of them and see which one is the letter that you're looking for. So in a nutshell, and long story short, it made we saw that it was practically impossible to get a hold of these documents and therefore to react. There were other complications there. The fact that indeed the repertoire was indicating that these documents were submitted. There was nothing in terms of a response. And the mandate of the repertoire, in all the way when it was established in 1952, in Resolution 686 of the General Assembly, the title of the resolution that created the repertoire is Ways and Means for Making the Evidence of Customary International Law More Readily Available. So if you have these documents in the repertoire, which in principle is the repository where you would look for evidence of customary international law from the perspective of the work of the Security Council, but they are not accompanied with any response, then it also gives a misleading interpretation of how the law is being built. And so based on all of these things, we thought it was important to start taking action and to think of how could we do that. And so one of the things that came to mind was, of course, just bringing this issue to all of the debates that we could within the Security Council, within the General Assembly, and to mention these issues. But of course, knowing that there's also a lack of access to the information by academia, civil society, researchers, to know that a state or a group of states made a reference to their interpretation of Article 51 in one particular debate of the General Assembly within the context of the Sixth Committee, for example. It's also very difficult to get that. So there was a need to also give more visibility in conjunction with other partnerships and civil society, so that it wasn't only an issue that was discussed here at the UN, but that could also have more visibility. By the way, some have said that, well, at the end of the day, I mean, it's the competence of the Security Council if they want to look into these issues, and maybe it's not a big deal if the letters are not circulated to all the membership, because the Security Council can discuss these issues. And in principle, that sounds good. However, I would still highlight that in the last report of the Security Council to the General Assembly on the work of the General Assembly, on part 5 of the report, the document is A/73/2. There's a section called that there were issues that were called to the attention of the Security Council, but which were not discussed in the period of sessions that is covered by the report, which is basically 1 year. And we identified only in that section at least 5 of these letters that were submitted to the Security Council invoking Article 51, which were not discussed by the Security Council in any of its sessions. So third part of the presentation then, what did we do and what did Mexico decide to do? We formally submitted a proposal to the Special Committee of the Charter, which is a subsidiary body of the General Assembly, to discuss the scope, the interpretation, and the implementation, the current implementation of Article 51, and to tackle 2 aspects. 1, all these issues that have to do with transparency and accountability, and 2, the substantive issues that have to do with how do we interpret Article 51. Why did we go there? Because the mandate of this body is precisely one that allows for all member states of the General Assembly to discuss issues related to international peace and security in the interpretation and application of the UN Charter as a whole, so that there's this one forum where all states can have a conversation and a discussion. And so we thought what we need is that. We need the space, and we need to give member states the space to voice their views, to know what the issue is, to study this issue, to educate themselves, and to position themselves before we can draw a conclusion on what's the status of the law and where the law stands. We formally introduced this proposal last year. All of this is publicly available. If you go to the webpage of the Special Committee on the Charter and you go to the 2020 session, new proposals, on new items. There's a non-paper submitted by Mexico, which has a brief introduction of the why, and then a series of questions that we're proposing the special committee to discuss. That document is also translated to all 6 official languages. And also at the very bottom of that webpage, there's a document with our introduction of this paper to the special committee on the charter. So that one is only in Spanish, but if you're Spanish-speaking people, you can also look at it and get a more complete idea of what was the intention and what's the rationale of us behind this. And then the last point of our way forward and where we stand. Because this has taken so many years and it has taken so much time, it also coincided now with the fact that Mexico, starting January this year, is now an elected member of the Security Council. And we notice as well that this is a quite unique opportunity to cross these cables between what we've been doing and what we've been saying in all other possible fora, especially in the General Assembly. And again, I repeat, and we've been also stressing these issues out in open debates in the Security Council in the past. But now, what do you do from within the Security Council? And these letters, by the way, continue to come in. Just this week, on the 26th of January, we received another letter from another member state that made reference to the absence of an ability to deal with the presence of terrorist organizations, invoking Article 51. So this continues to happen. Again, it's not something that just happened in 2014 and now the practice has stopped. So at least as a way forward from within, we think that there are several things that can be done. The first one is that we have to bring this issue, and we will, to the subsidiary body of the Security Council that deals with working methods. Basically because we think there's a problem of transparency and that then links to accountability. If these documents are public, then there should be a way that there could be more readily available for all member states, especially when it's a legal requirement established in the UN Charter itself. It's not something that came from any other source. Second, we really think that the Security Council should give a more thorough follow-up and consideration to these letters instead of just receiving them, which is what has been happening so far. The Security Council receives them, they're circulated to the members, but that's pretty much it. There's not a discussion or a follow-up. And this is key when we're talking about the actual use of force. And that is the cornerstone and the pillar upon which the UN is built as a whole. So these issues cannot be just brushed aside. And third, we still need to have this push between all the things that we're doing and saying in the General Assembly in conjunction with the Security Council to create congruency and uniformity of these messages. And I think that, Emily, responds a little bit to the question that you made at the end of your presentation of how do we measure failure or success. I think the first thing I would say to answer that question is that when you arrive to New York as a UN delegate, you realize that you're part of a very large community of 193 member states. So you cannot come just with the measurement of your success being what was the proposal that you passed, because you depend of other 192 countries. And it's like, if that's the bar, then it would be a terrible bar to stand up for every single time. So for me, success has to do with how much do we or can we member states individually contribute to the whole organization moving forward on the issues and its agenda. And from this perspective of this panel on how we contribute to moving forward international law, to securing the implementation of international law, to making sure that when necessary, we go to the basics of what is it to respect and implement international law. And for that, you need to make waves, you need to make noise, you need to talk to people, you need to make the issues visible. That is already a success. Even if you're talking about no resolutions adopted, no decisions being made, the fact that there's awareness, openness, transparency, that's already a success, because that in turn will create this tension for accountability. That in turn will lead to results and to changes in attitudes. And that's basically what we've been trying to do from the beginning. We will continue to do that. We know also that the time within the Security Council goes by very fast. 2 years is nothing. So we'll try to make the best out of these 2 years. But that doesn't mean that when we leave the Security Council, then it's over. We continue to be active members of the United Nations, and we continue to have a responsibility as such. And therefore, the issue here is how to use all the tools that we have available to make these issues real issues that are taken into consideration, including through the opportunities and the tools that we have while being in the council. So I'll stop there. Thank you very much, Chris, for the time, again, to the Geneva Academy, and happy to continue with the conversation in a few minutes.
Fantastic. Thank you very much, Pablo. And I really appreciate the words at the end, which give me a little bit of hope, because I, like you, when I arrived in New York, I had all of these ideas about various things that we could do. I still have quite a few, some of which we've been a little bit successful with, but many others that are a struggle and a daily struggle. And I think you're absolutely right. If you measured success by, you have 20 things to do, and only if you get 18 of them done are you being a success at your job, I think you'd have a few people that would be a little bit despondent. So I really appreciate that and understand that. And I just wanted to say as well, thanks to Mexico for all of the support on a number of files that are interesting for us. And certainly we look forward to that collaboration. Thanks also for outlining the project that you have relating to Article 51. Of course, the ICRC, we're not as involved in ad bellum, but or 512427. But of course, those have an impact on our work. And so we're always very pleased to see what's been doing. You mentioned as well that you were quite involved. This idea came about because of some of the work by Naz and her team over at Harvard, and we're very lucky to have Naz with us today. And I believe Naz will be speaking a little bit about an area that is, of course, extremely important for us, for the ICRC, for international humanitarian law, and for the work of humanitarian organizations in situations of armed conflict. And that is the relationship between counterterrorism law, certainly the law developed after 1373, after the events in September 2001, and its relationship to other bodies of law. And in this case, I think notably IHL, and the work of some of the bodies of the United Nations, including organs affiliated with the Security Council. So perhaps, Naz, over to you for a little bit of a description of that area of international law at the Security Council.
Excellent. Thank you so much, Chris. And my special thanks to Emily and the Geneva Academy. And I'm really thrilled to be here with my colleagues and, more importantly, my friends, Chris and Pablo, to have this discussion. So as Chris suggested, I'm going to tell a story that I think touches on the important questions that Emily ended with, that if you have law already, what role should the council play? And what if the council brings that body of law into conversation with an entirely different set of norms and objectives? How should we think about that? So I will start with two relatively pessimistic comments on the relationship between counterterrorism law, and I put quotes around that, and international humanitarian law. I'll give a few observations from a 2020 report we wrote on the relationship between CTED, the Counterterrorism Executive Directorate, and IHL, and then I'll try to end on a note of optimism, as Pablo just inspired me to do. And I want to emphasize, I think, in light of the way Pablo ended, that in our view, in my view, 2021 is a crucial year for exactly the kind of engagement Pablo is talking about. 2021 on the issue of counterterrorism and IHL at the council is a year that states, if they are paying attention, if they are listening, if they want to choose not to be silent, may have a unique opportunity to make themselves heard on issues of the relationship between counterterrorism and international humanitarian law. Again, I want to emphasize, I'm really only talking about at the council here. There are lots of fascinating relationships between counterterrorism and IHL at the municipal level, at the regional level. I won't be addressing any of those. Okay, so 2 points of pessimism after far too many years working on this issue of CT and IHL. The first is that IHL compliance and IHL doctrine will not solve this problem at this point. There may have been a time when perfect compliance with IHL could have done away with any potential tensions with the counterterrorism resolutions of the Council. In my view, that day has passed. Second, that Security Council exemptions alone will not solve this problem at this point. So even if we were to wake up tomorrow and the Security Council were to decide to issue an absolutely overarching omnibus resolution that would create exemptions across the board to its counterterrorism resolutions, we would still have a series of dilemmas to contend with on this issue. Okay, so that's my two pessimistic points. So what about the role of CTED, the Counterterrorism Executive Directorate? We came to start thinking about this really as a result of conversations with Pablo and with many other legal advisors in New York, as we were discussing the Security Council Resolution 2462 of 2019, and particularly as we were realizing in our dialogue with member states that there was a significant amount of confusion around the question of the relationship between IHL and counterterrorism in that resolution, but also in terms of CTED's mandate. So CTED is a technocratic security body. It appears to be a special political mission of the Security Council, but for our purposes, importantly, it is a technocratic, bureaucratic body that has been given the mandate by the Council and by the CTC to conduct assessments of member state compliance with and implementation of the counterterrorism related Security Council resolutions. So in my view, a pretty awesome power to visit every member state on the planet Earth and determine if those member states are appropriately implementing and complying with their obligations under the Council's many and ever-growing counterterrorism resolutions. So in the words of a 2017 resolution, CTED's core function is to conduct a, quote, neutral expert assessment of the implementation of counterterrorism resolutions. And they primarily do this through the country visits, as I mentioned, and then designing capacity building, technical assistance, and other means by which states might better implement their counterterrorism obligations. What piqued our interest and our concern ultimately here is the increasing sense that CTED was also being tasked by the Council to pay close attention to the Council's references to applicable international law in light of counterterrorism. And this is what I want to really emphasize. How do we understand what it means to implement and to assess compliance with international humanitarian law through the lens of a resolution that is focused on counterterrorism and through the oversight of a technocratic body that is dedicated to the implementation of and compliance with counterterrorism resolutions? These are CT-oriented bodies and CT-oriented resolutions that are now referencing and bringing into conversation IHL, a far older and pre-existing body of international law that, in the view of many observers, exists on a different plane than the Security Council's CT resolutions. So I'll just read a language quickly from 2462, probably familiar to many of our audience members. The Council demands that member states ensure that all measures taken to counter terrorism, including measures taken to counter the financing of terrorism, comply with their obligations under international law, including international humanitarian law, human rights law, and international refugee law. Coupled with a 2006 guidance to CTED, noting that when analyzing states' implementation of CT resolutions, CTED should provide advice to the Council on states' implementation of international law in light of their counterterrorism resolutions, and advise the Council on how to ensure that member states are taking measures to implement their international law obligations in light of counterterrorism measures, we began to wonder, what does it mean for CTED to do this? And this is in a context, and this I think connects in some ways to the lack of transparency that Pablo referred to, of a body whose country visit reports are not publicly available, whose technical assistance efforts are not publicly available, and whose day-to-day operations are largely behind closed doors and often in conversation with a very limited number of members of the Security Council. So I think it raises two central questions. One, who should develop, interpret, and apply IHL in light of counterterrorism? Not in the country or context specific manner that the council has done in the past and that Emily's report and her remarks refer to, and that we might celebrate as being sort of good for IHL, but rather in a much broader legislative lens that increasingly suggests that it is appropriate to talk about compliance with IHL through the language and the normative universe of counterterrorism. Not necessarily a natural fit and not one that we need to necessarily accept as a sensible approach for the council to deal with IHL moving forward. Second, what does it mean to talk about IHL being implemented through these country assessments and technical assistance and advice of a body such as CTED, which is not an IHL expert body, does not have, to our knowledge, a deep expertise in international humanitarian law, and where it is questionable whether the council has mandated CTED to undertake this task, and whether the council could mandate CTED to undertake this task in light of the fact that, as we know, international humanitarian law treaty body instruments are ratified by all member states, and where, of course, there is a significant role for the high contracting parties to the key instruments of international humanitarian law to be the main arena in which that implementation and potentially compliance assessment is thought about. So I'll just close with a few questions that states might ask themselves as they think about this. And I'm happy in the question and answer to talk about what some of the implications might be, but just to give you a bit of a sense of this, it might mean, for example, CTED engaging in a classification of armed conflict in a particular country visit. It might mean CTED determining what are the status of individuals and groups in a situation of armed conflict, again, in providing this assessment to the council, really getting into some pretty contested and challenging areas of IHL as implemented, again, through the lens of counterterrorism. So as states think about this, I think it's important to note that we are anticipating a report from CTED to the council in 2021, this year, and that this may be a real opportunity and a moment for member states to determine their own view on whether or not CTED ought to be engaging on these issues more broadly, and importantly, providing assessments of compliance or views on the interpretation and implementation of IHL. So I think one question is, does Security Council Resolution 2462 or any other resolution mandate CTED to assess international humanitarian law? Should the Security Council mandate CTED to assess international humanitarian law through the lens of CT? Are CTED's interpretations and assessments binding as a matter of international law? So if CTED is engaging in this activity, where does that fall in terms of authoritativeness in the language of and in the view of international law? And should CTED's assessments be made available to other member states? Is it important for member states as a whole to be able to better understand how CTED works and what approach it is taking to the assessment of other states' compliance with its obligations under the Security Council resolutions? So I'll close with my note of optimism. I think that it's something to be optimistic about, that states are increasingly becoming aware of some of the more, not secretive, but perhaps closed activities of the Security Council, that states are increasingly realizing that the silence that Pablo referred to earlier may be interpreted or misinterpreted by other states as a kind of acquiescence. Whether that's appropriate or not as a matter of international law doctrine, functionally, that's what may be happening. And finally, I'm optimistic about the idea that member states will insist that the critical political and legal dimensions of international humanitarian law in 2021 and beyond belong with states and not with technocratic and other bodies that seek to provide their expertise and their assessments behind closed doors. I'll close with that and I look forward to the discussion.
Thank you very much, Naz, and thanks for ending on a note of optimism. In addition to not wanting to be too despondent from what Pablo mentioned, it's nice to hear that there are some positive areas that we can look forward to and maybe count on and keep in mind as we go forward in an area like CT, which has been challenging. I'll note as well that I think at least I see in the attendees at least two folks who work at CTED, so perhaps they'll offer us any thoughts on the questions you posed at the end in the chat. Certainly, we'd be happy to have them. I'll maybe turn now to the first question, and this I'll pose to Emily. And just to say that when I read the report, the briefing that you did, my initial reaction, but again, I'd be curious to hear how you thought about this, was maybe certainly it wasn't optimistic. I'd say even it was sort of trying to temper a little bit ambition, saying, hey, this is difficult. Just understand there are challenges when you try to bring these topics to the Security Council. And yet when I heard you speak, you were mentioning about maybe some positive examples. You mentioned, for example, hunger, healthcare, and disabilities and missing persons, where there has actually been an expansion of the POC agenda in the last few years. And so I'm wondering a little bit, are you a glass half full person or a glass half empty person on what's possible for elected E10 members? Is it, and maybe I'm mischaracterizing it. So I'd maybe like to get your thoughts on that, and maybe just related to it. One question that was posed to us, maybe it sort of links to it, is what your thoughts are. This is from Lucy Wordsworth Russell. What are your thoughts relating to perhaps increasing mistrust and perceived illegitimacy of multilateral organizations among the public and at the state official level? So how states view organs like the Security Council, how individuals view it as well, and if there's anything we can draw from those in it. So over to you, glass half full or glass half empty?
Thanks, Chris. The first question I think is a very, it's a difficult one. I think I'm a glass half full in the sense that I believe in the power and the important role that the United Nations and its organs can play. But I'm also a very pragmatic person in the sense that I don't think in the current, when law is actually used for political purposes and is being implemented for the pursuit of also political gains and not necessarily always humanitarian considerations, I don't know whether action is always the best choice, especially if you're serving on the Security Council and want to address IHL related issues. And if you look at the example of the resolutions you and I mentioned under the POC agenda item, I think it exemplifies that every choice you make has consequences and costs you something. So you might have a multiplication of issues that the Security Council is not talking about that are being mainstreamed through the UN system and also integrated in, with things that field missions have to report on. But it also contributes to the fragmentation of the agenda. And does the UN have the means to actually implement what those resolution promises? So I think I'm a pragmatic in the way that I think when the political stakes are this high, states, in my view, should be very conscious that they're making a choice. And choose, in French, you say choosing is renouncing something. And what do you actually renounce is when you push an issue forward and when you absolutely want to have a product while serving on the Security Council. So I'm a glass half full / pragmatic, if that answers your question. And to the second question with regards to lack of trust in institutions, I think it really relates to what Naz and Pablo mentioned with the lack of transparency. I think the Security Council, if you're not based in New York or if you're not really interested and familiar with those issues and have or are lucky enough to have access to the right people who can take you through the dynamics and explain to you where to get the information, I think it's very difficult to understand what the council actually does, how it actually does it, how it takes decisions. And I think the public, from the public perspective, it can look as lack of action or inaction on certain issues. And if you had more transparency in terms of working methods, notably, I think it would help with trust. If that answers your question.
Thank you. Yes, thanks very much. Maybe the next question now over to Pablo. Maybe if you could just share a couple of thoughts on if Mexico has a position on what makes a resolution binding. So for example, do you need the word decides in a resolution? Does there need to be a declaration that there's a threat to international peace and security? Do you need reference to acting under Chapter 7, for example? Just a little bit about the legality, and maybe linked to that, what is the effect of an article, so under Article 103 of the Charter, of a decision of the Security Council? So Article 25 of the Charter talks about decisions and that they're binding on all member states. 103 says that the Charter prevails in the event of a conflict between a treaty norm and the Charter. The whole question about what you do with higher level peremptory norms. But anyway, just sort of that. So does Mexico have a position on a Security Council resolution that says that decides to do something, and whether that takes precedence over other treaty obligations necessarily, or it has to be the decisions don't get caught up in that 103, let's say, power, if that makes sense. If I'm not clear, please, I can try to clarify.
No, thank you, Chris. It does make sense. So let me try to give a short answer to that. So the point of departure, I think it's Article 25 of the Charter. Article 25 says that the members of the UN agreed to accept and carry out the decisions of the Security Council in accordance with the Charter. And that basically links to the legality and the obligation to comply with them. Something that has always struck me as very interesting is that Article 25 does not say decisions adopted under Chapter 7. It just talks about the decisions adopted by the Council. So, I mean, I think there's a general consensus by now that the decisions of the Security Council are legally binding on member states. I think that's the reality that we have all assumed, and that's the world in which we operate. But in order to fully tackle this issue of the crossing with Article 103 and the role as a legislator of the Security Council, I think something that we also have to bear in mind is that there's an additional challenge added to this, which is that the Security Council is the main political body of the organization. So you have a political organ making political assessments and political considerations that translate to law. And that can become a difficult, challenging thing, especially in an area like city, where I would also use the air quotes of NASA, what now we call city law, is the consequence of a series of decisions by a political body that impose obligations on member states. But they did that precisely because of the lack of a global framework that was internationally agreed and that was created by a legal body or a legal organ to set the rules that are applicable for counterterrorism. We still don't have the General Convention on Terrorism. It has been on the freezer for almost 2 decades now, and I'm not very optimistic on that seeing the light anytime soon, talking about Sisyphus. But that means that then the Security Council is the one body that has been taking decisions, not from a legal expertise point of view, but from a pragmatical political point of view, creating this piling up of obligations which patch certain things and that make this issue more complicated. Challenges that have to do with IHL include precisely the notion that there's a political distinction by many council members on whether IHL is actually the applicable law or not. And if you don't have an agreement of what's the applicable law, then it's very difficult to just assess how do you follow up with implementation of, if people don't agree that that is what should be implemented. And that has caused a lot of issues, which is many of the issues that Nas was talking about. So with all of this, quick comment on Article 103, as people know, Article 103 basically gives hierarchical supremacy to the Charter and the decisions that derive from the Charter to any other sources of international law. And so that in principle might suggest that if you have a body like the Security Council making decisions which become legally binding, if they end up being in conflict with other rules of international law, then the assumption would be based on Article 103, they are hierarchically superior and they supersede any other rules. However, I do believe that there is a chance to analyze and to question legally some of the decisions taken not only by the Security Council, but by other UN bodies, which would de facto constitute a judicial review of the work of the Security Council. And I'm very happy that this actually came up, because there was one of these conversations I had with Nas many years ago where she said, people who talk about Article 103 and judicial review, it's just like, you know, geeks that there are only like 15 people that are interested in this, but no one else takes a look at that. So I'm very happy that now we're coming down to Article 103. There's, of course, a huge discussion on whether you could take this issue to the International Court of Justice for judicial review or not. And there are some precedents, some of them with advisory opinions. That's a completely different story. But at least I think there's room to question some of the legal reasoning and the motives behind some of these decisions, either in terms of challenging the way in which they should be interpreted and implemented, or the way in which they should be reinterpreted and restated by the Council itself. And this is one of where the Council has an advantage, being a political body, that instead of it just issuing a judgment like the ICJ, where then it would be very difficult and it's very complicated for them to change the sense of the judgment in their dicta throughout time. They mainly confirm these things, and when they want to change an idea, it's a huge thing, and they really, like, the court really has to explain why. The Council doesn't need that. The Council can just change its mind because politically it was sound. It was a sound decision to change its mind and change course. And so I think that also gives us the possibility to look at these issues, yes, from a legal point of view, to analyze their impact and their consequences, but to way faster be able to go back to the Council and revisit them, because if this is a piling up of patches, then we might need a new one. And we have seen that happening. So that I think that would be where the pressure of Article 103 comes into play, if that makes any sense.
That's great. Thank you very much, Pablo. I hope we have time. I think we'll have time for one more round to go. So there's a number of questions actually, as you've been speaking, that have come up actually in the chat for you on those. So it's obviously a topic of interest. Maybe I'll turn over to Naz, and there's been a couple questions. I think you've seen some of them in the chat, but I wonder if you can also maybe address whether you think the general licenses that the US provided relating to the Houthis on the 19th of January, where you've got now, and Venezuela may have been the first example, but you've got clear expressions for certain, humanitarian organizations on official business, very broadly defined, for activities on a CT-related sanctions regime. And whether that gives you any hope for replication in the Security Council, kind of how you see it. And then maybe secondly, if you have any thoughts for elected incoming members, certainly there's 5 incoming. We've been having chats with a number of them. And if there are either some international law or IHL related topics that you think that they should really be focusing. Pablo said, you know, maybe you can't get resolutions, but at least you can turn the attention to a certain area. Are the things that you would highlight and recommend that they take up in the course of their 2-year term?
Great, thanks so much, and thanks to the participants. Really fascinating questions being presented. So one, just to note, if I could quickly say, based on Emily and Pablo's comments, I think it's important to acknowledge, and of course I sound like I'm being very critical of CTED, but I'm of course really being critical of the Security Council, right? It's CTED that's being mandated to adopt certain approaches and policies. But I think for all of us, for international lawyers, using the Security Council to achieve things is extremely appealing because we lack for institutions that can carry out enforcement and adjudication, as Pablo talked about, right? That of course there are other options, and they are very much discussed often in the academic realm. But of course, when you have the chance to utilize the council to expediently, particularly through Chapter 7, get something done, there's a real draw to do that, even if as a matter of process, you may have critiqued that in the abstract previously, right? So I completely understand that all of us, I think, are drawn to the notion of using the council for what we think is a good use of the council's ability to act quickly and overcome obstacles and barriers. And I think it's something we just deal with when we talk about the work of the council, particularly in this kind of legislative mode. Let me say a word about the general licenses. So for audience members who are not familiar with this story, the United States in the final days of the Trump administration made a move that I think was almost uniformly advised against, which was to designate the Ansar Allah, or the so-called Houthis in Yemen, as a foreign terrorist organization in the context of the US legal system. And without going into too much detail, there was an outcry from the humanitarian community indicating that the implications of this designation could be devastating. Indeed, a number of senior humanitarian actors indicating that it could push many communities in Yemen into famine and into far greater hardship. Alongside of the designation, the US, through the Department of Treasury, issued what I think, and I haven't verified this coherently, but I think this is right, are the broadest general licenses ever provided vis-a-vis a designated terrorist organization by the United States government. So essentially authorizing full-scale transactions with the Houthis as long as they are humanitarian organizations and for humanitarian purposes. Chris, to your question, I think what is tricky here is, do we run the risk that if we go down the road of discussing the technical elements of licenses and who they cover and who they don't cover, so for example, there's a big question right now, what about importers? What about private for-profit actors that are critical to the survival of millions of Yemenis because of that country's reliance on imports? How are they treated by these? I worry that if we go down that road, we in essence avoid the bigger question of the designation in the first place, that it was a mistake to designate the Houthis, and that the implications of that designation will be far reaching and cannot be solved by these general licenses. Or is it better to say these licenses are a win? They are a recognition by the government of the United States that the humanitarian action question is crucial and must be considered alongside any designation. And indeed, as you suggest, could be an example to the council for how to do this. I think it's a very tough question. My sense is that in the particularities that we are dealing with today, it is crucial to maintain the pressure that this is a designation that can and perhaps ought to be reversed, despite the extensive nature of the licenses. When it comes to the council, I think the tricky nature of licensing in the US is actually a great example of how difficult this could be at the level of the council. While the Treasury has licensed these transactions vis-a-vis the sort of elements under its domain and purview, the Department of Justice in the United States maintains the ability to prosecute individuals for material support to terrorism, even for activities covered under the general license. And I think it's a good example of some of the difficulties that the council itself could run into if exemptions are seen as a way of approaching some of the dilemmas created by the encounter between the counterterrorism resolutions and principled humanitarian action in particular contexts. Sorry to have taken up so much time with that. I'll just give a second to the important question about what advice to the council. To states entering the council, I think exactly as Pablo suggested, if member states entering the council, if elected member states can view the range of action as being far beyond pen holding, resolution drafting, and can consider the idea that they may be in a position to draw attention and debate and discussion to particular issues and draw in more member states to those discussions and issues, I think that's an area where I would advise any member state to look at questions of protection of civilians, questions of IHL, and think about where are those areas where you think shining a light on a particular topic might really expand whose voice is heard and what topics are brought to the agenda at the council.
Great, fantastic. Thank you very much, Naz. And in fact, you touched on exactly what I hope you would, which was a material support and the fact that that remains. So thank you very much for doing that. We've got about 8 minutes left. So what I'd like to do is to cycle through with a few other questions. I may have missed some, but I know that the panelists can also see things in the chat. So I'll maybe turn it over to each of you to answer those. I'll start maybe with Emily and actually ask you the same question. I know you're not a state, but imagine you are. And I know that in your report, you said, yes, but you have to look at what the interests of the states are. So maybe make up the state of Emily Max. And if you were about to come onto the Security Council, what would be a few of the areas, one or two, that you think, yes, actually, I would like to highlight that. I think there is room for progress given what we've got right now at the Council. And then I know that there's been a couple others. If there's any other ones that you want to touch on, for example, there's one on the role of civil society and the ICRC, and then how much Security Council states are listening to civil society as well in CT and other related ones. Over to you, Emily.
Thank you, Chris. In answering the first question, I think I want to echo Naz and Pablo's points, which is coming in, you have to see the broad range of tools at your disposal for highlighting an issue, and those go well beyond just having a presidential statement or a resolution. And your action can also consist in giving voices to others and inviting and giving platforms to civil society organizations, for instance. But I think rather than choosing a new issue, I would try to look at issues that others had carried on in the past and build on their work. First, because you could go to those states and ask them what were the challenges that they faced and the hurdles that it went through and what in their perspective would be an added value to their work. But also because, it's all about incremental work and being patient and being Sisyphus in a way and carrying an issue for a very long time, like Mexico did with Article 51 and silence. So I think, healthcare remains, I think, a big challenge, and especially so now with also the COVID-19 pandemic. So it's definitely an issue that is worth building on. And the whole, CT framework, I think also, and sanctions and exemptions, and thinking about those issues that Naz mentioned with the role of the council mandating seated. I think those are the two issues that I as a state would try to build on, because others have done so and started the process, so it's easier for you. But then you can also pass the baton to others. I think when thinking about your tenure on the council, it's important of thinking of what happens after you leave and how you stay engaged on a specific issue after leaving as a member of the broader UN system. And with regards to the role of civil society or, you know, other UN organizations and agencies, and do states listen to them? Yeah, they do. And I think it's also the role of those agencies to proactively approach states and seek dialogue and say, hey, we know that there is this resolution being negotiated and we're worried about this language, and this is what we do on the ground. And I think you have states actually, you know, genuinely being open to those conversations with ICRC, with OCHA, with MSF. And I think it's been on resolution 2462, if I'm not mistaken, I think it's been crucial in achieving some of the language that is in the text. And ARIA formula meetings are also one of the ways where you're, as a council member, free to choose who to invite and who to give a platform to. And it's about opening up, you know, it's about making the council more transparent to the world, but also bringing the world at the council. And I think as an organization, you should not underestimate the power that you have if you actually seek contact with states on issues that are being worked out at the council. I don't know if that answers your question, Chris.
Thank you. Yes, very much so. Thank you very much, Emily. Maybe Pablo, over to you for two questions. One was a question from Harut Ekmanian in respect of Article 51 in Nagorno-Karabakh and how you see that, including sort of military action and kind of a peace process and the status of it. So that was the first question. And then the second one from, I believe it was Tariq Jarad, who asks why Mexico is concerned about unable and willing and whether there are fears that it could be invoked against the territory of Mexico. Over to you.
Thank you. I'll respond now with snapshots because I'm conscious of the time. So with the first one of Nagorno-Karabakh, I think part of the problem is that the Security Council is not a court of law, it's a political body. So you can have this issue being raised and discussed, but eventually if we want an assessment of the legality of invocation of Article 51, that probably should go through legal channels. Second, why Mexico is interested in unwilling and unable? Because it's the right thing to do, because it's a principled position that we've always had, because the UN Charter itself was built under the premise that we were outlawing war and that we were creating a collective security system that forbids law with a couple of exceptions. And if we start creating cracks in that rule, we create cracks in the whole collective security system of the United Nations. And we simply cannot afford to allow that to happen. A different story is that the way in which the precedent is being framed, it's very tricky because it doesn't say that you're allowed to invoke Article 51 when it comes to terrorists who are acting under the blah, blah, blah in the context of ISIL. If the dictum that arises from this is you can invoke Article 51 against non-state actors when a state is unwilling and unable, then the margin of possibilities that are open for anyone in the future, including Mexico, yes, but for anyone in any part of the world are huge. But it's a matter of principle. And very quickly, on listening to civil society, I think the fact that we presented something after having a conversation with NAS, which was civil society opening our eyes, raises, I mean, it makes me rest my case. Second, on this distinction between permanent members and elected members, I know that the notion is always that we are second category states, but there's one thing that I would like to highlight. We are elected members. We have the legitimacy of an election. We are now in the Security Council because 187 member states of the UN decided to have Mexico in the Security Council, not because we chose to. So we have a bigger responsibility to the UN member states as a whole to act on behalf of the organization. So this is not an issue of us feeling a second category. On the contrary, we're empowered by the fact that we have the General Assembly backing us up, and we're very happy to be the country, Mexico, that got most votes on that. So that would be my final.
Thank you very much, Pablo, for that, and for the note about the number of votes that Mexico got to get onto the council. Well done, excellent. Last word over to you, Naz. There was one question about, we should be looking at CT through IHL rather than IHL through CT. Why can't we do it that way? And are there any, that links maybe to 103 and just how the two work together, but anything else you've seen in the chat? Over to you.
Yeah, fantastic. So I think on the Article 103 question, and I think Emily's talked about this really, really eloquently as well. I think it's important for member states, I think, to remember that there isn't going to be a kind of correct doctrinal answer out there in the world that is going to answer this question. Member states need to continue to insist on how they understand Article 103. And I think to be watchful of articulations of 103 that start to shift the way we understand the relationship between international law properly defined and resolutions of the Security Council. So I would just say it's dynamic. You need to keep paying attention, and you need to keep thinking through how do you as a state wish to understand this relationship, rather than thinking that sort of international lawyers are going to answer that question for you. And second, I think about the question of viewing CT through the lens of IHL, as a number of the commentators point out in the chat. A key aspect of this is IHL's relationship to parties to an armed conflict is very different from counterterrorism's understanding of non-state actors that are party to an armed conflict. And so one of the things we stand to lose here, if we are not mindful, is the way in which IHL seeks to ensure that all parties to armed conflict abide by the rules. And there is a real risk here that if we subsume IHL within counterterrorism, we lose many of the carefully calibrated elements of IHL that are specifically crafted for situations of armed conflict, which is not what CT is, nor does CT seek to be that. So I think it's a really important idea to think about how do we kind of reorient where CT falls within the broader domain of public international law.
Fantastic. Thanks very much, Naz. Well, we've reached the end. I think I personally feel that at least Sisyphus may actually be able to move the boulder a little bit further up the hill. I'm not sure whether that will be ultimately successful. I think only time will decide, but at least I think I come away with it with a little bit of optimism for 2021. And certainly given 2020 and COVID and everything else, I think we could all use a bit of that. So on behalf of the Geneva Academy, who organized this, the IHL Talk series, I want to thank you all very much for attending. It's been a rich, wonderful discussion, and hope to see you at the next talk. Thank you very much. Bye-bye.